Hey, Brian Parker here with another exciting adventure in learning how to defend yourself against collection lawsuits. Today we're going to title this one, Collection Defense Hack. What do I mean? A hack has many contexts, but we're going to sort of give you a cheat sheet to write the best defense if you choose to follow my instructions. Again, this is being given under the auspices of the Entertainment, Information, Research Value, UBU, but I think you'll be in a good place if you take a look at my tips, incorporate in your own state with the state rules. So you got this lawsuit. What do? There is more to help you, because the first thing you get this lawsuit, what I always preach, hack into their documents and use their own documents against them. So you want to think in terms, as I always preach, about the counter affidavit. But also I want you to think about chips and bricks. Chips and bricks. I always preach each thing you find is not a wall, it's a brick. But you also want to look at the fun things you find from their documents as a chip, meaning you got a chip now that you can use against them, either to settle the case, end the case, or win the case. So first thing I want you to do is, did the lawsuit that you were served with get served with a summons? A summons is usually exactly what it says. It's you're being summoned to court, and that's called a summons. And it outlined, depending on the state, various rights or things that you have to do within 21 days, 28 days, 30 days, depending on the method of service. But the first thing you can look at for a chip or a brick in a wall is to look at, usually a lot of these have sections that say, has there been a civil case filed previously? In fact, let me share what that looks like in Michigan. Shazam. And that's a summons. And you can see in the middle there that the summons is saying, no, there has not been any other civil filing. You'd be surprised how many times, yes, there was. And they're saying no. Well, that's a chip. That's something you can point out when you have this long laundry list of things you're going to point out to the collector that maybe they should settle this case. And again, go up to my How to Settle Cases with Debt Collectors video. That's a lot of fun. It's under 30, as I'm going to try and make today. But look to see if they misrepresented the fact that a lawsuit has previously been filed against you. I knew of one law firm, and hopefully I contributed to stopping this, that they would file a lawsuit, use the subpoena power to go get the information from my client's banks, and then let the lawsuit just dismiss. All they want to do is get the subpoena power. And some rules were changed because of that. And then they'd file the lawsuit again with this information they got that they wrongfully got last time. It's kind of cool catching people doing that, because at the first, I'm a naive person, always have been. And it just shocked me that someone would do something like that. But this part and parcel is how they have to say if there was or wasn't a lawsuit. In some states, it requires you to put the case number of the lawsuit previously filed. It happens. People do what they do. So also look at the date of the summons. The summons comes with a beginning date. In some states, it's 3 months, and an expiration date. In other words, you have to be sued for this case to be going against you within that starting date and expiration date. It happens. They'll serve you. Sued versus service, You have to be served with the lawsuit within the 3-month or 4-month date starting the lawsuit and the summons expiration. And it does happen where at the last minute they'll serve a client beyond the expiration date. Well, that's a chip or that's a brick in the wall that you can use to address settlement very quickly to save you, and if you're an attorney, your client, a lot of money. What's the address on the summons? We're still looking at the summons. The address on the summons is everything. A good amount of time I see summons with the wrong address, because this is a lot of times old debt with old addresses. And if they sued you in the wrong district that you haven't lived in, and my rule of thumb is about a year or two, they've sued you in the wrong district, you got a lawsuit against them. That's a big brick, part of a wall, and definitely a good chip. If the debt is for $10,000, now you've got about $35,000 to $5,000 claim against them. That's a chip. Separate from who the defendant is versus the collector that you're probably going to sue, but you can sue both the plaintiff and the collector and the collection agency in that regard. It's a chip. Look at the complaint. I want you to rip the complaint apart. And I'm going to put a complaint on the screen now, Shazam. And you can see that I put FF, and I've preached this before, TT, and that's, you read it. If it's true, you put true. If it's false, you put false. Look at the trues. How do they impact you in your case? Look at the falses. How do they impact you in your case? Falses are fun. Truth is always good, but you're going to have more fun with the Fs. And in looking at the Fs, if you look at paragraph number 4 on the complaint, it's telling you when the debt was created and also when and the account number accompanying that came along. You'll be surprised again that the account numbers don't mesh up with perhaps the account statements that they attach to a lawsuit. Again, a lawsuit generally has the summons, the complaint of about 4 to 12 paragraphs, and then all the proof. In some cases, debt collectors don't attach anything. But when they do, that's stuff that you can use against them. So you're going to be looking at the complaint again. You rip the pages apart. Take a pen, FF, true. If the true doesn't hurt you, go to the false. The false always hurts them worse than the truth hurts you. It's a rule of thumb. So look at when the lawsuit says the account was started. Is that true? In this case, it's 2004. And you look at the account number. Do they match up? If not, you got a brick, you got a chip. There's always an agreement, or sometimes a cardholder agreement attached to the lawsuit. So they can say, hey, look, we got the agreement, because that's part of the account stated statute. And it's never signed by the client or you, or it's an electronic signature in some cases. See if your state allows that type of electronic signature. A lot of student loan, they put your signature in there whether you signed it or not, and it's just a bunch of numbers. So look at the signature. It's a chip. Could be a wall if it's a false signature from your state, or someone added it and your client knows they did not add it. In your agreement that they have, whether it's student loan or a credit card, make sure that the lender is the lender that initially was the original creditor. I see a lot of cases, especially in student loans, where the chain of title is all screwed up, but the lender is the wrong lender. I actually have a case now where the 10th assignee, meaning 9 other people own this debt, is saying it got the debt from the original creditor, and then in the complaint it puts itself. It sold itself or bought from itself, and it's not. But there's so little care put into these lawsuits. That's a chip for you. That's a piece of a wall. If it says it's an account stated, it generally will say it's an account stated statute lawsuit. It'll be breach of contract, account stated, if they have the contract, and unjust enrichments, I've said in the past. It'll say it. So here's what you do. If you're in Michigan or in Florida or any other state, see what the rule is. What are the elements? Whether it's criminal or civil, eventually when you go to a jury, it has to meet every element. You only have to knock out one of those elements. And the elements in account stated statute generally are, have the parties expressly said we have an agreement, and the person you are alleged to have made some payments and you haven't objected in time, which is see all my counter affidavit, killer affidavit, look up, videos, which are enormous help. It seems like everything I do now is focused on that. I apologize, but I don't, because it's going to be very helpful to you. And as I try cases to juries, repeat. So please get that counter affidavit. And by the way, everything I'm telling you right now goes in your counter affidavit. So you're writing it and you don't even know it. Make sure the elements, again, of your state that say how an account stated comes about match up with their complaint saying why you have an account. And it's real easy. Look at the exhibits. This is where you have some real fun. The exhibits they attach to the lawsuit are, that's where I feed. Look at the loan agreement. Again, it's a phony, false signature. Ask yourself if you signed that document when they're claiming you did sign it. Is there an arbitration clause? Aha! As you know, I've done a video on solo suit, and you can look up and see the video I did on solo suit. It's a review, and it's a bad, I would not follow, caveat emptor on solo suit. But solo suit is now making money telling people to go to arbitration for this reason. It makes the other side settle cases. It doesn't. I just received a case of a client that had 4 cases where she followed solo suit's advice. Now she's in arbitration, not having a clue what she's doing, and it's time and money. It's a money suck. It's a time suck. And the law firm is going all in on each case. She's been talked into a big mess. I got a hold of it and settled all the cases. Arbitration agreement is in every agreement. Thing you're looking for is the arbitration, and there are some that say this, saying that only lawsuits filed up to the amount owed in small claims are allowed to be filed. Otherwise, the whole thing has to go into arbitration. But then a debt collector will come along, having bought it but not read anything, and will sue the client anyway. That's a big brick and a big chip. Look at the assignment clause of the loan agreement. Again, you're using their documents against them. Let me put an assignment clause on the screen. Shazam. Okay, so that seems like it's a big mess, but if you read just a little bit, you'll see that every assignment of the debt from the original creditor to the client or the person that's suing you now has to be registered. What do you think the odds are? And I'll tell you why the odds are really bad that everything that's been assigned is in that register. I've yet to see it. And number 2, with securitization, this thing has gone to so many places that no one dares talk about. You can win your case. In this case, if you look at the assignment clause on screen, there's an address. Write a letter. Be as benign as possible. If you want one of those letters, I'll give you one. I'll put it on collectionstopper.com in Podcast Plus, a letter to this particular company. If you have another clause from another agreement with obviously a different address, blah, 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 just use that as a template. But send it certified, return receipt requested. Keep a copy of the signed letter and be real specific in your letter, as I have been. And don't accept nonsense when they realize they have to be truthful and they're not being truthful. They'll email you usually in response to get rid of you. Be forceful and put everything in writing. Keep copies. Keep a paper trail certified by mail. That could be big. If it doesn't work out, well, when you're sued, as you probably have been, that's why you have this, then you can subpoena their records. You can, I can, anybody can. In fact, they voluntarily said, write to us, and you'll see that the plaintiff that's suing you is not listed in there. Check it out. Here's an interesting thing. Attached to the lawsuit, a lot of times, especially creditors' lawsuits, will be your account statement. So for the month of August 2021, here's the statement. she did this, you did this, you paid this, you did this. If you haven't made a payment or haven't purchased anything in the documents, then that hurts them in their account stated claim that you participated in this debt and you came to an agreement. Because that's why it's attached there, to show that clearly if you use the card, you agreed on the card and the obligation and all that. But here's a couple of tips. Take your own August 2021 statement that you have in your possession or online and match it up. Why am I saying that? Because a lot of these are bits and pieces all put together to be an account state. Because this stuff gets purged. Nobody's keeping account statements for more than a couple of years. So check it out. If you've got one, match it up to what they've got. If you find differences and cut and paste, which you might, in their documents, that's more than a ship, that's more than a wall. Is that spoliation of evidence? No. It kind of is, because if they're giving something that's separate from the actual best evidence rule, best copy, that is kind of spoliation of evidence. So look into that, and you've got a big chip and a big brick there. But again, they're attaching those documents, account statements, to show your use of the card. If you have no use of the card in these statements, or there's no payment made by you, they're worthless. So they're just something you can stuff your mattress with if it isn't as springy as it used to be. This is a thing. If you get something big where it could either go into litigation, where they should have arbitrated instead of suing you, and their own document says this, don't file a motion for arbitration as solo suit is telling you. My advice, take it or leave it. It's too messy and thorny, and it just makes greater messes. File a motion to dismiss and say, I'm not wanting to go into arbitration. And I'm not telling you how to write anything, just something you should contemplate. It's better to file a motion to dismiss than a motion to compel arbitration. At first glance, you're going to go, oh, I'm going to put him into arbitration. They'll be mad. No, they won't. And if it's a law firm, they're like, oh, good, I can get lots of fees from this because he filed for a motion for arbitration. So file for motion to dismiss. And don't say I want to go into arbitration, just saying they had no right to sue me, and leave it there. The other side will contact and go, oh, so you want this to go into arbitration? I would not agree to that. And you can use this as a big chip to contact them first before you file the motion, because you've got them. So don't let them tell you otherwise. It's their own document. I'd avoid motions to compel arbitration. Inside the document will also be what's called a choice of law. These are fun. It says right in the agreement. Now remember, you're getting sued for breach of contract. 99 times out of 100, these agreements will say this lawsuit must be filed in a state you don't live in. 99 times out of 100, I see that. The only time I see where it gets the state right, it's when it's like a Michigan bank or a Florida bank. Let me put on the screen what a choice of law provision looks like. Shazam. See that? In this case, it says additional agreements. They want this case in California. If they don't do that, now remember, they've sued you, whatever state you're in, then you can say to the court, they're accusing me of breaching the contract, and this choice of law provision specifically says sue in California. Isn't that a breach of the contract? And if they don't have clean hands, they can't be laughing at your dirty nails, meaning you come to court with clean hands. So that and the motion to dismiss, things like that, should be filed often and early. Don't waive those rights. Any rights you don't bring in your affirmative defenses, you lose. So look up your state's requirement as far as bringing something like a motion to dismiss. A lot of times you can bring a motion to dismiss without having to file an answer, which could actually save you time and money. Look at my video on filing motion, summary judgments, summary motions generally. Here's a cool thing. The state that they are suing you, the provision has the choice of law provision, the statute of limitations may be less than what they're suing you in. For example, I've got a Florida case that says you got to sue in California law. Florida, it's 5 years. Student loan debt in California is 4 years. So you got rid of that case just by using the Parker principles. Now you're using your brain by talking to Parker. The assignment clause, again, is something to look at for a number of reasons. Number one being, do they have a right to assign your debt? They're always going to say, we have a right to do it and not tell you. But anytime they say to you, hey, we didn't sign this, you got an assignment clause. And I've used just that and said to the court, look, there's an assignment clause. Clearly, this is going on. Most of these debts are securitized, so you're not going to see assignors or assignees of this debt that went into a trust, which they all have. That's something to look for. What I do is I'll do a chain of title, and I'll just go, here's the creditor, here's an arrow to who says they own it, here's an arrow who says they owned it next. Was there a signature? Was there a date? Was it certified? Hey, there's something missing here. So look at the sales documents. In Michigan, for example, and I'm sure many states are like this, it would make sense, especially Ohio is a good one. They have to be assigned a certain way. It must be a signature. If somebody else has signed this, not a member of whoever is signing this, there must be an affidavit of authority. That's the case definitely in Michigan. In a case called Brownback versus Bay. I'll put it on my website, collectionstopper.com. It says specifically you got to show the authority of the person that signed the debt. So let's put on the screen a bill of sale. Shazam. That's a general bill of sale. In this case, there's nobody showing who assigned this to the person that eventually saying they assigned it to someone else. You can see it's all done pursuant to a purchase-sale agreement. You never see the purchase-sale agreement in these documents. So how do you do all these things pursuant to a purchase-sale agreement that you're not providing? So that's a chip and a brick. When you ask for that, that becomes a big chip because they do not want to give that up. It tells you all the secrets. In that bill of sale on the screen, look how many things certain people are saying they did. Their services, their additional buyers, their additional sellers. That alone is enough to win that case. Just got to get the right judge. Map out in a chain of title, just on a piece of paper. Who owned it? Who's the servicer? Who's the seller? The initial seller, by the way, is the original creditor. Just use that information and now look at that bill of sale. It's being sold to a company who's clearly not the original seller. And it's a trust, by the way. Look at that. It's a trust. It's a trust. The bill of sale shows it's clearly being securitized. Who knows how many hands have had that. But this crap goes on all day long. You have to do a little bit of work to get this brought in front of the court. But map out who really owns this debt if you can. If you can't, make sure you tell the court in the counter affidavit. Anyway, so the affidavit of the collector is a huge thing they rely upon, especially in Michigan under the account stated statute. Do the same thing I asked you to do with the complaint. Rip the affidavit off, put false, true, false, true. The false is going to be that she has personal knowledge. She doesn't, because you'll see that all the other entities that are attached to the lawsuit as having previous ownership don't make it into her affidavit. Look at the date of the affidavit. That's a hack. Is it before the lawsuit? 100%. Yet you're called a defendant and the plaintiff's called a plaintiff when a lawsuit has not been filed at the time she swore under oath that you were a defendant and they were plaintiffs. So that's a breach of her duty. It's not, what do they say? Lawyers don't ever say lie. They always say that client, defendant's being disingenuous. So that's not true. So how does she have personal knowledge of something that didn't happen? Also, if she's not listing the assignees or the assignors, which are clearly obvious in their own paperwork, she doesn't have personal knowledge. Why am I saying personal knowledge? Because no affidavit is good without somebody saying they have personal knowledge. Here's a 99 times out of 100 tip for you. Most of the time, these custodian of records that sign these affidavits, this one too, let me put it on the screen. The affidavit, in this case, that is a person that doesn't work for the company she says she does. And a lot of times these companies work for either a third party or a holding company of the company they're signing for. But she says she's a member of this one company, and in that case, she isn't. Look at the name of the affiant that signed the affidavit and look for her signature. That's fun. You'll be surprised how many times that isn't her signature, or the notary is not her signature. These are hacks again. You're separating all the paperwork. Lay it on a big table. Put your F's and your T's. Compare the dates of the lawsuit when it was filed versus when she signed the affidavit, always before. In some states, she has 10 days. The affidavit's only good if it's signed within 10 days of the lawsuit being filed. That's a tough thing to do. I haven't seen it. Unless it's a local, yokel law firm, sometimes their own attorneys will sign the affidavit. I love that too. It's just to get that date connected within that 10 days. Look for spelling errors. What are you, a teacher? No. If they have personal knowledge, how do they mess up your name? That happens. Do they refer to you as being a he when you're a she? That's a brick. It's not a chip, because you're not going to go, hey, look, you called my blah, 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 especially in this day and age. But if you don't know the person, you don't know the debt, and you don't own the debt. So look for those little chips and bricks. Some are chips. This is a hack video. Do these things. Separate your pages. Map out who owns the debt. Map out what's true, what's false. What are the elements of the things they're charging you with charging? If they're not the same as what they've got in the body of the complaint, you're going to win that. That's a chip and a wall, because you got to have the elements to win the case. All right, trying to keep it under 30. This is the video hack, and hack those guys. You can do this. Just use my advice, incorporate it with your state statutes. All this that I just told you, I'm pointing in my notes again, is how you create your counter affidavit. Counter affidavit is so important, whether they filed an affidavit or not. Someone asked me, hey, do we still have to do that if they didn't file an affidavit? Yes. Why? Because we're showing the court why you can win. They're hearing from you. Plus, the tip, we put in our counter affidavit. We put in our counter affidavit. Hey, debt collector, you owe us money. And if you don't pay us when I file my counterclaim, you've got 10 days to deny it under statute, in some statutes, some states, or you owe me money. That's between you and me, right? But that's what statute in a lot of states says. It's good for the goose, it's good for the gander. All right, I hope I've hacked this bad boy. I've kept it under 30. I thank you. Please subscribe and like, but more importantly, comment. Go to collectionstopper.com, Podcast Plus. I'll put my show notes so you don't have to look at this face again. And thank you if you do want to look at this face again. Comment. I do videos if you ask me to, and I will, because I enjoy working for you. Thank you very much. Have a good day.